Welcome back everybody to our studies in the law of tort for the SQE specification. In this lesson what we're going to do is spend some time talking about the duty of care. One of the very key issues and one of the first things that you're going to have to think about when we look at the discussion regarding negligence. When we think about what is required for understanding how negligence can be established in a tort case. Of course, there are a number of different steps that one needs to essentially traverse when thinking about the law of tort, and the question of duty of care is the first of these basic questions. We'll ask in this lesson what the duty of care essentially is. We'll talk about its historical development, the key foundation of the duty of care in the case of Donoghue and Stevenson, and think about how this has developed over time, looking specifically at novel cases as well. Fundamentally, one of the things that has developed in the last sort of 30 or so years is the fact that a duty of care will exist in certain locations, but what about in certain situations in which there is no established authority on whether or not a duty of care exists? How do the courts approach that particular question? That will be the topic of this lesson, as well as thinking about this in future lessons as well. So what is the duty of care? What is this idea of a duty of care? Well, it's essentially a legal obligation, it's a legal duty that is imposed on an individual, requiring that they conform to a specific standard of conduct. So where the tort of negligence really gets its sting, where it gets its ability to attach to and litigate against so many people and so many circumstances, is the fact that the courts have established that there exists in sort of society this general idea that people who are acting in a certain way will act in a way that should not harm an individual, should not act in a way that harms an individual. And if they do, then there could be liability in tort for that. If the duty of care there is breached, therefore, and damage results, the defendant may be not liable in negligence. But traditionally, this idea of a duty of care didn't really exist in the same kind of way, because it was traditionally understood that a duty of care existed, let's say, between some kind of contractual parties, let's say where there is an explicit duty of care that's established there. But the case of Donoghue and Stevenson is the case that really expands this idea and expands it to broader society, such that you have a duty of care to your neighbours, essentially, is the sort of general principle that we think about. And so Donoghue and Stevenson is a very foundational case. Mrs. Donoghue drinks a ginger beer that had inside it a snail, and that snail caused her to become ill. The bottle was opaque, so no one could see inside the bottle. And the question is that clearly there is some harm that has been done, and so there is a tort somewhere on its face. But who should Mrs. Donoghue sue? Should she sue the person who who sold her the beer? Well, this is difficult because it actually wasn't her that bought the beer. She doesn't have a contract with the manufacturer. She didn't have a contract with the retailer. That's because her friend bought her this beer. Also, the retailer had no idea there was a snail in it either, because it was an opaque bottle. Well, then in that case, should she sue the manufacturer? Because the manufacturer must have acted negligently in some way to allow a snail to get into the bottle. Well, again, she doesn't have any contract or contact with the manufacturer, either through, even if she had bought the beer herself, but even through the fact that she had the beer bought for her. Well, the House of Lords held that the manufacturer did in fact owe her a duty of care. And it is not necessarily the judgment of Donoghue and Stevenson that's so important, although it is very important, but also in addition to this, the obiter from Lord Atkin, who enunciates this idea of the neighbour principle. The neighbour principle, which is, like I said, established in the obiter of Lord Atkin's response to the case, but is then picked up on and elucidated and then sort of entrenched in law further on in the future, and is sort of picked up as the basic principle by which we can see how a general duty of care can be established between people, even if there is not a contract with the person to whom you think a duty of care is owed. So Lord Atkin opined on the duty to take reasonable care to one's neighbour. That's basically the idea, and it's a sort of harkening back to the idea of loving thy neighbour from biblical texts. Who counts as a neighbour is the really important question. So one must take reasonable care to avoid acts or omissions which they can reasonably foresee would likely injure your neighbour, and that provides us with another additional bit of information, this idea of reasonable foreseeability. But then the next point is really important, because who counts as a neighbour is broadly defined by Lord Atkin. Because Lord Atkin says that who counts as a neighbour is people who are so closely and directly affected by my act that I ought reasonably to have them in contemplation. So let's think about that as we apply it back to Donoghue and Stevenson. The manufacturer doesn't have a contract with Mrs. Donoghue. They have a contract, presumably, with the retailer, who has a contract with Mrs. Donoghue's friend. That's sort of how the chain of linkages relates there. But the manufacturer would, in producing these ginger beer bottles, have or should have had in their mind reasonably believed that if they were to act in a way that was negligent, let's say they were going to act in a way where they didn't clean the bottles properly and there was bleach still in the bottles and that could cause harm, it would be reasonably foreseeable that that harm would be caused to people who would drink the bottle from the bottle, even if you, the manufacturer, don't have a contract with that person. And so that's what we mean by neighbour. That's what we mean by sort of proximity and reasonable foreseeability, having them reasonably in our contemplation. When thinking about our actions, I'm thinking about my actions. If I do this thing, what effect will this have on other people around me, essentially? So neighbour doesn't necessarily need to mean the person next door to you. Just like in the biblical text, love thy neighbour doesn't necessarily mean love the person next to you. It means love others around you more broadly. And so neighbour is quite a broad contemplation, but it's people who you ought reasonably to believe will be affected by the thing that you are doing or the thing that you are not doing, if we're talking about the case of omissions. So this establishes this idea of both foreseeability and a sense of proximity, okay? But it hasn't formally explicitly made that clear just yet. The case of Ans and Merton, however, is a little bit more developing in terms of the test. Here we get what becomes known as the Ans and Merton test, which establishes a broader development for the duty of care, but takes on the characteristics of the neighbour principle from Donoghue and Stevenson. It establishes basically a two-part test, which asks the question, firstly, is there sufficient relationship of proximity, i.e. neighbourhood, based on foreseeability between the claimant and the defendant? So, fundamentally, is there a certain degree of closeness, shall we say, nearness to the claimant, such that there should be foreseeability, that you should reasonably foresee that there could be some kind of interaction or there could be some kind of harm that is brought about as the result of your negligent conduct. And then the second part is, are there considerations which ought to negative or limit the scope of this duty, i.e. are there potentially policy reasons for limiting the scope of the duty? Now, this was a test that is ultimately partly overruled, especially mainly because of its broad scope, and is replaced by a more refined formulation in 1990 with the case of Caparo Industries and Dickman. Caparo and Dickman is good because it provides us with a structured three-part test for determining in novel situations where a duty of care arises. So a novel situation, i.e. being a new situation. So let's say you are thinking about a case where it's a doctor and patient relationship. Well, there's been lots and lots of case law on the doctor and patient relationship and whether or not a duty of care exists in those situations. So that would not represent a novel situation. But what about a completely new situation in which there is no case law, in which you are thinking about basically establishing a new duty of care in this particular kind of relationship? Well, in that case, Caparo and Dickman provides us with a three-part test for determining if there is the existence of this duty of care. The three-part test requires foreseeability of damage, i.e. is the harm reasonably foreseeable? It requires proximity, a relationship of closeness, so very similar to that of Ans and Merton, i.e. is there a certain degree of proximity between the claimant and the defendant, i.e. that doesn't necessarily, again, have to be physical proximity. It could be a closeness in terms of just the relationship, such that your actions could have an impact on the claimant. And then the final one is, would an imposition of a duty of care, if we are to impose a duty of care, would that be fair, just, and reasonable? This is ultimately a case concerning auditors preparing accounts for a company. We'll get to the facts of that case in the next lesson. But more generally, and more recently, in fact, we've seen a reaffirming of these principles from Caparo and Dickman, but with a slight caveat attached to it. The case of Robinson and the Chief Constable of West Yorkshire Police was a case involving an old lady who was on a high street, and the police were planning to apprehend a suspected drug dealer, and they knew that this old lady was there, and they were trying to get this drug dealer, and they ran past her and knocked her over, I believe, and caused some kind of harm. And the question was, well, is there a duty on the part of the police to sort of take care for the reasonable population when they're conducting things like a drug bust, for example? Well, the Supreme Court reaffirmed that there is obviously no blanket immunity for the police in all those kinds of circumstances, but they also provided with a slight variation, a slight adjustment on this idea of novel standards. They basically came to the conclusion that the test that you use in Caparo and Dickman is still a good test for truly novel cases, but that Caparo should not be applied mechanically in every single case, and that there should be an emphasis first on looking at existing cases, looking for precedent, and then if there is no precedent for this particular case for application, there should then, the next step should be to look for circumstances in which there is analogy, where you can look and analogize and see if there's any kind of similar kinds of circumstances. So let's say if we're talking about like a doctor and a patient, and let's say for hypothetical scenario that there wasn't a duty of care in that circumstance established, maybe according to the case of Robinson, maybe they would look at the analogy of a nurse and a patient, and then maybe if there isn't a duty of care there, then we start thinking about applying the rules of Caparo and Dickman.